All right, we'll recap those headlines a little later on. Sorry about the technical glitch. We do have a question of the day for you, and we'd love to receive your comments. Use hashtag #FullView on Twitter. And this is about another social media platform, WhatsApp. So the latest WhatsApp update, users have been warned, means that group admins could be legally responsible for what other people post. So this could be an issue if you are the administrator of a WhatsApp group, and we'd love your thoughts. Is this something that concerns you? Are you careful when you engage on WhatsApp groups? Are you aware of this change in how things work? Hashtag #FullView. All right, let's go to our top story. State witness in the Senzo Meyiwa murder trial, Sergeant Thabo Mosia, would not be drawn into whether the bullet found at the scene is linked to the accused. Mosia has been testifying at the North Gauteng High Court, where 5 men are charged with killing Senzo Meyiwa during an alleged robbery at his girlfriend's mother's home in Vosloorus in 2014. He was the first forensic officer to arrive at the scene, but says he did not take swabs of the bullet. Mosia was probed about contradictions in his statement and the statement of the late Brigadier Ndlovu's in the second docket. This statement has been admitted into the record as hearsay evidence following an application by counsel for the fifth accused. Mosia repeatedly testified about Ndlovu instructing him on what to do when he arrived at the crime scene. But Ndlovu seemingly distanced himself from any involvement with Mosia. So 5 men are accused of murdering the former Bafana Bafana goalkeeper, and that trial continues, but there are now questions around the testimony of the first forensic detective to be on the scene. Let's bring in attorney and legal commentator Mpumelelo Zikalala. Mr. Zikalala, great to have you with us as always. So you would think if you're hearing from a detective first on the scene, a forensic detective, this could be crucial evidence which can be used to convict or set the accused free, but now it's all complicated, isn't it?
Definitely. Good evening to you and also to your viewers. Let's remember, we do not have an ordinary witness on the witness box. We have an expert witness, someone who has the necessary skills, have been trained, has got the necessary experience to be able to tell the court exactly as to what happened, and also to let his own finding do the talking for him. Now, if the defense is going to poke holes in the methodology that this particular expert witness has used, his assessment and how he was told to conduct this investigation, then it proves the narrative which is going to be driven by the defense of saying, even though you ought to be a qualified expert witness, you have failed to provide your expertise in this particular matter, and you simply regurgitated what another person informed you to say, and we cannot rely on your expert witness because really it does not come from you, it comes from somebody else. I think Advocate Mpumelelo, the defense, has been pretty much successful in doing that and in showing instances in which a reasonable doubt can be drawn from the manner in which this particular witness conducted his investigation.
Yeah, and to make things worse, so he says he took instructions from Brigadier Ndlovu, who is late. He died before the trial began, and he admitted an affidavit saying that he had nothing to do with Mosia. So now that is being treated as hearsay evidence, his affidavit. Just explain sort of what weight that carries.
At the moment, it does not carry much weight. Reason being, we can't cross-examine the affidavit without the person who drafted it, and unfortunately, because they've passed on, there's absolutely no way that you can test the accuracy of that particular, though the content of the statement, which is why we do cross-examinations in the first place, just to check whether the accuracy and the probative value of whatever that the person is pushing or is stating is indeed true. Now, if the drafter of the affidavit is no longer there, then it cannot help us. However, it does not mean that you can throw away that piece of evidence which may be crucial in certain instances. It can be used to collaborate some of the evidence that may come or some of the evidence that you want to dispute at a later stage and allow that piece of evidence to be re-evaluated by the court. So the court will then say, I'm going to look at the probative value of this particular evidence, then I'm going to assess whether I'm going to admit it, and then also assess how much weight should I give to this particular piece of evidence. If there are other instances or other witnesses that can come in and say things which are similar or in line with what the affidavit is saying, then there are more chances of the court accepting this particular piece of hearsay evidence, even though it can't be re-examined. So we still wait to see whether this particular affidavit is going to keep propping up here and there just to prove or to show instances of inconsistencies in the particular witness statements which are going to come in, or witness evidence which is going to come in at a later stage.
So we have two police officers, one late, contradicting each other. So you would need other police officers or officials like that to clarify this as the trial goes on.
Yes, you do. But another thing which will also assist you is also the material that has been obtained. So you then look at the evidence that is there, and then you have to ask yourself, would a police officer in the shoes of the current witness conduct themselves in this particular manner? That's when you are looking at the probative value. Did this particular conduct happen or not? And then you then look at what ought to have been done in the first place correctly to allow us to arrive at the correct conclusion. If there are any instances of doubt that are taking place, or in any instances where there could be other explanations other than the explanation which has been provided by the state, it increases the chances of the accused being found not guilty. Let's remember the burden of proof which is being attached to the state. The evidence or the line of questioning and explanation that comes from the state must be the only reasonable inference that can be drawn, or all the facts drawn up together will lead to us thinking that the people who are in the witness box are they indeed the real perpetrators, and they conducted this particular bad crime in a manner in which you said they have done so. If there are any instances of doubt or alternative arguments, it increases the chances of them of being freed, because you haven't sufficed the burden of proof of being found guilty beyond any reasonable doubt. There will be instances of reasonable doubt which would be thrown in here and there, and that's the role of the defense attorneys or the defense legal representatives in this particular manner, to make sure that they keep on showing these instances of doubt.
Well, let's see what we're left with from today. Thabo Mosia is saying that he did not take swabs of the bullet. So questions about how that crucial piece of evidence was dealt with, and he couldn't say if the bullet was linked to the accused or not. Is that a gift right there to the men standing trial?
Definitely, because what then says is that would a reasonable investigating officer who would consider an expert, or forensic officer who would consider an expert, not take the necessary swabs or deal with that particular crucial piece of evidence in the manner in which Advocate Mosia, Mr. Mosia dealt with it in? If the answer to that is no, they should have provided extra care. They should have provided extra diligence and provided extra duties to make sure that they extract that piece of evidence that should be able to tell us who that particular gun belonged to, when was it fired, the name and make of the particular, or the caliber of the gun. Then it could assist us in finding this particular crucial question. If you haven't done that, all that you are proving to the court is that you don't even warrant to be called an expert witness. You have failed in conducting your duties in a manner in which you were taught in a manner in which you have relevant skills to execute that particular duty in. And the evidence which you are presenting to the court can't be trusted. Even though it would be admissible, there should be no weight that should be attached to it, because you have simply failed to do your duties. You're not assisting in this matter at all.
Overall, I mean, this was one of the highest profile murders in this country, where there is a lot of crime. At the same time, we have two police dockets naming different people. Now we have conflicting affidavits, or testimony in an affidavit, and concerns around how evidence was treated. Is it all sort of building up, questioning the way police deal with big crime scenes?
I think the most headache that could be caused by this matter is that it could be a perfect example of how not to conduct an investigation, a perfect example of how not to conduct a prosecution in any criminal matter. What the state ought to have done, at the instance of two dockets being known that they do exist, is to sit down, mirror the two dockets and say, these are the statements that favor us, these are the statements that don't favor us, either due to inaccuracies. Let's investigate whether these inaccuracies are due to people merely forgetting because this particular incident happened over a long period of time, or is it because of people are lying? If a person is lying, let's bring them and make them co-accused, and also charge them with perjury, and then say, you are acting in common purpose with the accused that are in the witness box, and we need answers from you, unless you are all going to go down for the same crime. If you don't do that, you are going to have this accused being freed at the end of the day because of lack of evidence, and you can't bring other individuals or charge them for the same crime, because the evidence would have been laid bare in the public at this particular point in time, or you would have had those particular people that were meant to be co-accused giving evidence in this particular manner. And the Criminal Procedure Act is very clear in terms of self-incrimination and using that self-incrimination or prosecuting that individual. And then you can't have someone in which you are going to hold accountable for the murder of Senzo Meyiwa. The state needs to sit down and then say, are we prosecuting this particular matter correctly? The manner in which you should have investigated it from the law enforcement agencies, this horse has bolted now, you can't go back anymore. However, let's save what we can by making sure that our prosecution strategy is up to the point and it's going to guarantee a conviction at the end of the day.
All right, thank you. Legal analyst Mpumelelo Zikalala looking at the latest from the Senzo Meyiwa murder trial.